Assalamualaikum warahmatullahi wabarakatuh. Good morning, everyone. I'm Ridayana Nigaso as a facilitator for today. Welcome to the class with the subject Indonesian legal system. And before we start, I remind you to open your camera and mute your microphone. Firstly, let's pray with each other beliefs. Pray begins. Okay, for all, please remind your friends for joining the room because the class will start 1 minute left. Okay, to minimize the time, I invite the lecturer for today, Mrs. Adiningtyas S. Jatmiko. Time is yours.
Thank you, Bu Ridayana, and hello, good morning or nearing afternoon for the others. So my name is Adiningtyas Jatmiko, but you can actually call me Sasa. I am a legal officer from the ICRC. It is the International Committee of the Red Cross. And before that, I would just wanted to ask if is my audio audible? Is my voice audible, Bu Ridayana?
Pardon me?
My voice is audible, right?
Yes.
Okay, thank you very much. So let me share my screen, and it's nice to see you all, although virtually, from the Capiz State University, the University of Malaya, and University of St. Anthony. Thank you so much for being here. Thank you so much for connecting through the Zoom, through this platform. And of course, before that, we thank you so much to Universitas Ahmad Dahlan, who has really been a very important and very valuable partner for the ICRC. So yeah, let me share my screen and just want to check if my screen is audible. My screen is visible. It is. So yeah, today we are going to talk about the humanitarian law, or international humanitarian law in Indonesian legal perspectives. And again, I'm from the ICRC. We are an organization, just a very brief introduction. The ICRC is an organization, international, that is akin to an international organization with a mandate specifically actually in the situation of armed conflict, or what you would probably call as war. And we aim to protect and alleviate the suffering of the people who are affected by war, with the mandate as well to promote this, what we're going to talk about today, the international humanitarian law. And the ICRC is present in many countries actually, including in Indonesia, in Jakarta, and as well also in Malaysia and Philippines as well. So we do have representatives of the ICRC in your states as well. So yeah, that's just like basically a brief overview of why we are here. We're partnering with the Ahmad Dahlan University. Thank you so much for that. Pleased to meet you all. And as a general rule of thumb, I am very casual about everything. So if you just want to ask anything right away, if there's things that you do not understand, just raise your virtual hand, or Buridayana can help me to inform me any questions that you might have in the middle of my presentation. I'm fine with that. Just like ask or request for clarification if I'm being too fast on some things. So yeah, basically that. And this is an overview of what we're going to talk about today. So first, I would like to say about why we are actually learning about this subject. Why is international humanitarian law, and why do we actually talk about this subject in the first place? That's the first. The second, I will introduce what is international humanitarian law, and it is important to know also how to implement the IHL, International Humanitarian Law, or IHL, and how are we going to further this kind of implementation onwards. Number 1 and number 4 will pretty much be very short. I will focus mostly on number 2 and number 3. So today, before we start learning about what we are going to learn, but what we are going to talk about, I want you all to probably indulge further on why we need to learn about this subject in the first place. And as you might have noticed from the snippets, or like some insinuation from what the ICRC is working on, and you will probably hear what I'm talking about: armed conflict, war. And this is exactly what we're going to talk about today. And why we must learn from that, I would like to invite you all to watch this video. Hopefully it is audible, but if it is not, let me know. Is the sound coming out? May I check, Buridayana, was the sound coming out from your end? Was there a sound from the video?
The sound is not coming
Okay.
out.
Let me unshare it for a moment. I think I forgot to click the audio. Is it coming out now? Okay, thank you. Oops, sorry. Sorry, pardon me for my inexperience and some technical difficulties. Let me repeat that.
Since the beginning, humans have resorted to violence as a way to settle disagreements. Yet through the ages, people from around the world have tried to limit the brutality of war. It was this humanitarian spirit that led to the first Geneva Convention of 1864 and to the birth of modern international humanitarian law. Setting the basic limits on how wars can be fought, these universal laws of war protect those not fighting, as well as those no longer able to. To do this, a distinction must always be made between who or what may be attacked and who or what must be spared and protected. Most importantly, civilians can never be targeted. To do so is a war crime.
When they drove into our village, they shouted that they were going to kill everyone. I was so scared. I ran to hide in the bush. I heard my mother screaming. I thought I would never see her again.
Every possible care must be taken to avoid harming civilians or destroying things essential for their survival. They have a right to receive the help they need.
The conditions prisoners lived in never used to bother me. People like him were the reason my brother was dead. He was the enemy and was nothing to me. But then I realized that behind bars, he was out of action and no longer a threat to me and my family.
The laws of war prohibit torture and other ill treatment of detainees, whatever their past. They must be given food and water and allowed to communicate with loved ones. This preserves their dignity and keeps them alive. Medical workers save lives, sometimes in the most dangerous conditions.
Fighters from both sides were wounded in a deadly battle. We were taking them to the nearest hospital. At a checkpoint, a soldier threatened us to treat his men only. We were running out of time, and I was afraid that now all of them were going to die.
Medical workers must always be allowed to do their job, and the Red Cross or Red Crescent must not be attacked. The sick or wounded have a right to be cared for, regardless of whose side they are on. Advances in weapons technology have meant that the rules of war have also had to adapt. Because some weapons and methods of warfare don't distinguish between fighters and civilians, limits on their use have been agreed. In the future, wars may be fought with fully autonomous robots. But will such robots ever have the ability to distinguish between a military target and someone who must never be attacked? No matter how sophisticated weapons become, it is essential that they are in line with the rules of war. International humanitarian law is all about making choices that preserve a minimum of human dignity in times of war and make sure that living together again is possible once the last bullet has been shot.
All right, so that was the basic overview of what the IHL is. And you might actually find it already controversial. Some of you might already find it controversial. How does war and humanitarian match in the first place? Like these seem like words that denote totally opposites meaning. And Yes, in a very advanced wording, I would like to say that yes, some of the concepts might not be too familiar with, might even come up appalling to some, but it is actually where the law, where in a situation where in war, some certain humanitarian standards need to be upheld. And before I continue, if I may ask kindly for some participants to mute themselves because the sound is coming from my end. Thank you. Yeah, I think there is a hand raised. Yes, Mr. Franz Chang, I think. Yeah, would you like to take the mic, please?
Yes, ma'am. Good morning. Good morning,
Morning.
everyone. So, in the events of war, it is inevitable to have collateral damage, meaning it is unavoidable to have unintentional deaths caused by these armed conflicts. So, my question is, would these be considered as war crimes still?
Thank you, Mr. Franz Cheng. How do I call him? Miss Franz? Okay, if that is okay with you, Franz. So thank you for the question. And it actually already shows that you might already be familiar with IHL actually, because there are some terms that which are very IHL norms, like collateral damages and then war crimes and everything. So yeah, thank you for the questions. And indeed, actually, I would like to emphasize what Francis just said, the inevitability of war, the inevitability of the casualties and everything, the collateral damages, meaning that in times of war, sometimes even the most unfortunate situations does occur. And yes, it might be a war crime to cause an excessive incidental or collateral damages to civilians. But the key word here is on the word excessive. International humanitarian law plays along in between the paradigm of reality, of idealism and pragmatism, that there is a situation of war, inevitably there might be victims, but it aims still to limit those victims. And that's why collateral damages, while in a way unavoidable in war, they must not be allowed when it is excessive. Well, we'll probably come around with this more when we are talking about the rules of proportionality, which is one of the core principles in IHL. But Franz, thank you so much for the question. I think it really already gives a very, in the beginning, a set out of what you might expect of this body of law that might sound controversial in the first place.
Thank you, ma'am, for your answer.
Thank you. All right. So why are we studying IHL? Essentially, we can already imagine more. If I may ask for perhaps Mr. or Mrs. Andrea Atuning to unmute them, to mute the audio first. All right, so anyway, in terms of wars, you might realize that there are impacts. There are, as Francis had already said, casualties, those that we cannot avoid, victims, deaths, injuries, destruction of buildings. And these are the humanitarian impacts that even though it might in reality happen, they must still be limited. That's like the core issue, the core rationale of the IHL. And IHL does provide all of these rules. It aims to protect and limit all of these bad things about war, technically. But even having the law itself, even having the IHL already set, it will be impossible if it is not implemented. At the end of the day, the victims will always be there, even when there is the law, if the law is not adhered, if the law is not implemented, if it is not observed. So it is very important to make the parties to the conflict or everyone taking the participations in the hostilities to observe these laws. And how do we do that? It is through the various efforts of dissemination, awareness building, and this is why we are talking about IHL, why the ICRC also has this mandate, why I'm today talking about IHL. It is, in retrospect, it would work in a backward fashion that through awareness building, even when in situation there is no armed conflict, this kind of awareness building is very important to be built from the early stage so that at the worst come to worst, when there is war, the worst humanitarian impacts can be limited. And that is why we are talking about IHL. So before I go to the second part of the presentation, This is a task, as I understand that each presenter must give a task on each subject. And the task on IHL is to find a short article, news, anything related to IHL. I would even take a tweet, a single tweet, like a couple of words or anything. You can even create a, like you heard from a friend of this issue, any issue, just write an analysis of said article or said statement or news from the IHL perspectives. You can take whatever angle that you want as long as it relates to IHL. It would be 500 word maximum. And what would be evaluated would be the legal references, because unfortunately, legal references, if there are any, and the analysis, the depth of the analysis, that will probably be the components for the evaluation. And I'm bringing this about early in my presentation, so just that you get an idea of what you might be expected to do, or if you want to, after this, during my presentation, there are aspects or angles of IHL that you want to focus on, you can probably get an early heads up for that, basically. I can elaborate more on the task later at the end of the presentation, but for now, I would like to introduce what comes to be the IHL, or the International Humanitarian Law. So when we're talking about a specific subject or IHL in general, and we will address the usual, what is IHL, why is IHL there, when, where, who, to whom it applies, and how it is actually applied. So when we're talking about the what, the first one, we would of course come again to the what is definition of IHL, where does it come from, what are the legal sources? And then we would need, actually, one of the question that I feel, when I was a student, I really did not pay attention to the question of why, the reasons behind something. When I was a student, this was like the question that I feel like, this is the most useless question ever. But if I may have an additional perspective, as I grow up, I would actually realize that the why question is one of the most important things that I feel and believe that all students must actually bring that into their awareness. Why is IHL? What was the history? What was the rationale or the objective of this law in the first place? And then we will talk about a bit of the technicalities. When does it apply? Where it applies? To whom it applies? And how, at the end of the day, would we apply this IHL? So what is IHL? And some of you might already have heard of IHL. Some of you might not have heard of IHL. Some of you might have already envisioned a vision of the humanitarian in IHL in your own language. And IHL, as I said, might be a bit controversial to some who think that humanitarian, to someone defining humanitarian in IHL. So basically, IHL is, among others, one of the branches of international law in general, public international law. And we come to know that there are actually other international laws. We do have international, when we're talking about war, and for example, France mentioned about war crimes, war criminals, we're talking about international criminal law. And when we're talking about war, sometimes we're talking about dispute, or conflict, and how to settle that. There is also the law on dispute settlement. Or when we're talking about war, we also come to think about why do we go to war in the first place? And is war in the first place a nice thing? Is war in the first place something that can be waged? And we're talking about the law and the use of force, and then the responsibility, and very much interlinked with IHL, also the human rights law, military law, refugee law, and there are actually abundance of other laws, international, public international law. They're very connected. But IHL, this is just to set out that IHL is related to all of them, but it is also a distinct body of law. So IHL, as you might already get from all of that, is the law, a set of rules that for humanitarian reasons aims to limit the effects of war. Again, really get from the word limit, it is that this law does not govern about the prohibition, justification of war, meaning it does not really revolve around why is war is waged. Is this country attacking that country something that is justifiable, or is it wrong, or is it, can it be prosecuted or something like that? We are not talking about that. It does not mean that it is not regulated. There is a regulation on how to, what kind of situations, under what kind of circumstances can use of force be waged, and very limited. They are governed by another branch of law, So in Latin, we call it the jus ad bellum, or the law before, or law going to the war. And it is, while it is related, it is distinct and very separate from IHL, the jus in bello, or the law in war. So we're talking about when war already occurs, when there is a situation that is unavoidable, such as war, how do we conduct war? That's kind of like the premise. So we're not going to talk about whether this military action by the state or not is acceptable under international law as a matter of the use of force. There is another matter, the law of force, the law on the use of force from the UN Charter would regulate that. But IHL, while related, would not really focus on that part. So that's the premise and the perception that I want you to have from the early on. It does not govern about the reasons, causes, motivation, but it does aim still in the situation of war to protect those not participating in hostilities and limit the hostile conducts of those participating in hostilities. And these two words, the protection and the limitation, would be like the two keywords that you would need to understand, to understand the spirit of IHL, protect and limit. So that's basically IHL and what it might be, and what probably an earlier perception of IHL is and what it actually is. And where can we find IHL, the legal sources? On an international sphere, or an international, as a matter of international law, we do have some sources of law, treaties, customs, general and widely principles of laws, and it applies to all types of public international law, actually. It does also apply for IHL, meaning that there are treaties, international agreements between states to govern IHL, and this is codified in the enshrined in the 4 Geneva Conventions of 1949. As you might also see from the timeline, 1949 is basically 5 years after the World War II. So really the Geneva Conventions, I would also elaborate that there are actually earlier attempts for this IHL, but the Geneva Conventions that we come to know now are what in the video earlier, there was a word of a modern international law or contemporary international humanitarian law. They generally derive from the 4 Geneva Conventions. And these 4 Geneva Conventions govern in the situations of armed conflict or war, but it focuses on different matters. The first Geneva Convention covers in the situation for the amelioration of the sick and wounded armed forces on land or on the field. The second one also covers a similar ambit, but it is more focused for those sick, wounded, and shipwrecked armed forces at sea. And then the third one, we're talking about the aftermath, or what one of the results of war, and sometimes we do have prisoners of war. That is what is covered under Geneva Convention 3. And then the fourth one is one of the most robust one at that stage, at that time. It is aimed to protect the civilians and in the situation of occupation. So the fourth Geneva Convention is more focused on the civilian side. And not only that we have Geneva Conventions, another key international instruments when it comes to IHL is also the additional protocols. In 1977, the first additional protocol covers in the situation of an international armed conflict, and the second one covers in the situation of a non-international armed conflict, or what we would call, you'll probably see it as IAC and NIAC. So the first one is in the international armed conflict, and the second one is specifically for the non-international armed conflict. And then there's another additional protocol in 2005 governing the use of emblems, which we might cover a bit if we have more time. But aside from these treaties, aside from these written instruments, agreements between states, you might also realize that some states might not always agree in writing on certain international law, and that is where, before that, treaties, while Geneva Conventions and the additional protocols are the key legal instruments, but there are actually other international agreements that while it may or may not be directly linked to IHL, they do have some IHL-ish components in them. This includes sometimes like weapon treaties, cultural property protection. So there are like myriads of instruments basically governing IHL in treaties. And after treaties, we do also have situations where, for example, like states do not want to agree in writing on something, do not want to reach an agreement on something, but doesn't mean that there is nothing that binds them. In public international law, there is a concept of a customary international law, and it also applies to IHL. There is also a customary international humanitarian law. These are basically the rules that are already considered as binding norms customarily, and it does have two components that we can talk about when we do have time. But basically, these bind even when the states are not ratifying a certain treaty. Of course, there are some requirements on what constitutes a customary international law in general and customary IHL. The ICRC does a study on what constitutes this customary international humanitarian law and tries to compile all of this from the practices of states, the doctrines and everything. And there is actually a very fast references on this. The third source, we call it like the very primary sources of international law, is the general and widely accepted norms of principles of laws. We're talking about elementary humanitarian considerations, the Martin's Clause, and a lot of general principles of law that are already considered to be widely accepted. Plus, there are soft laws, or what you would call like, the examples would be, for example, manuals, case laws, doctrines, teachings of highly published authors. So there are like some other experts or manuals or guidelines, UN guidelines, a lot of angles for the soft laws, which might not have binding power that is as strong as the harder laws, but they're considered in a way a recommendation and a direction on how to interpret all of the more primary sources of the international law. And because we're also talking about laws, international law, it is also interesting to find their relation to the domestic and national instruments, which are very important, and we'll come to discuss this more on the section 3 of my presentation on how actually these international law come to be translated in national instruments or domestic laws, basically. So that covers the what is IHL and where you can find them. And then we're talking about IHL and the history. And I would continue to stress how learning is history is actually very important to understand the rationale, the reason, the motivation behind this body of law. And as you might already get a gist of, from the very earliest civilization or humanity, war already exists. We might have heard of war already being waged centuries or perhaps millennia ago. So these are situations that persist as a matter of fact. And while they occur, there were actually rules that were already imposed even before that. And even if just like a very brief trivia, if the oldest known laws of war was actually existed in the Hammurabi Code, the Babylonian. And there's also references in Mahabharata, in the Quran, in the Bible. There are actually a lot of references on how people, even from before the modern setting, because they already are involved in war, they are actually already governing how war is or must be conducted. And then in the more modern setting, we begin to talk about the IHL as the term that we are coined now. IHL can be tracked back in the 19th and 20th century, when there are some initiatives, some war in that eras that gives birth to the more need of a more universal, more commonly acknowledged set of rules. And these are the earlier attempts to codify all of these rules that humankind probably already do, but have not been codified at that time. So these are the earlier attempts of the 19th and 20th century. And you would find also Geneva Convention 1864, manual from the Liber Code, a lot of early attempts to codify this law back then in the 19th century. But then as you would see, and you would also know that one of the worst war to ever took place was the World War II. And it really changes the pedestal of everything. It really changed the play game. It really changed the platform. It transformed a lot of sense, many aspects of law and how war must be conducted. So it gives birth to the UN Charter after the World War II. And the UN Charter governs about what I did mention as the jus ad bellum. It does not only cover jus ad bellum, it covers a lot of things, but among others are the prohibition to resort to armed forces, to use or the threat of use of force. And there are two exceptions. Those are the jus ad bellum that is governed under the regime of the UN Charter. And then we do also have the rules on war itself governed by the Geneva Convention. But as you might also see from the video, you would really think that, war, because it already exists from a long time ago, it might already evolve into something that we could not really imagine in the future. And this is where IHL is tested in a way, but I would actually strongly argue that IHL continues to prevail, even in the situation where the principles in IHL can actually still be applied in the situation of armed conflict of an unimagined nature in the future, because the principles are actually very core to it, very essential. And even when, say, technology has evolved into something, it has transformed war from its classical sense into something that is more, something unimaginable in the future, 50 or 100 years from now. The core essences of IHL would still continue to be relevant, could still continue to be, must still continue to be observed when even armed conflict continue to evolve into another types that even I cannot know what will happen in the future. So basically that's that. And this is the rationale of the law. Why I personally really like this body of law is because IHL is a very pragmatic law. IHL is actually, it is the law on balancing. And that's why there's a scale as an image there. So it balances the military necessity in war. Sometimes you do have to take military actions. Sometimes you have to, for whatever reasons, when, for example, states would go to war, whatever the reason is, state A may claim that they are the right one, and state B would also claim the same thing. Whatever the reason was, war was waged, and then there were some actions, military actions that are committed to the others, for example. And these actions are militarily necessary in war, for example, killing enemy combatants. But then, even when there is this push or requirement for military purposes, doesn't mean that it can be waged without limit. And that's where there is a humanitarian consideration. It pulls back. So this is IHL's really the push and pull between the two seemingly opposite stances. Military necessity on one hand, and then the humanitarian consideration must also be adhered at the same time. But it works in reverse, even in war, and even when we do have to apply humanitarian consideration, sometimes there are military necessity that make it imperative for us to abide by them. So these are really the push and pull between them. War is a harsh circumstance that sometimes cannot be avoided, but even still, in those harsh circumstances, there is a certain minimum human treatment that must be upheld at the basic level. And this is probably where IHL and human rights law in general might differ, because human rights law probably create the highest standard in a way of humanity, of human rights. But in war, when situations where you can imagine in war, there are some things that we take for granted now in peacetime might not exist in war. Some things that, as easy as internet, as easy as connection, as easy as communication, it might be the last thing that we are thinking of. We're thinking about running from bombs. We're talking about not knowing where your family is. We're talking about very harsh circumstances. We're talking about the possibility of you being detained probably for whatever reasons. These are the harsh circumstances. But even still, in those harsh circumstances, there are minimum, a very basic minimum that is non-derogable. So IHL is actually, a lot of things in IHL are non-derogable. Even when the situation are so harsh, there are a very basic minimum that must be upheld. And so this is, again, I keep on repeating this word, but I really want to stress out on how the rationale of IHL really plays on the balancing of the pragmatic or the realistic, the ugly reality of war. And on the other hand, it is actually about the noble idea, the idealism of the humanitarianity in war. So really these are the push and pull, the balancing of these two ideas that really creates IHL, that really sets out a lot of rules in IHL. So that's basically the rationale of IHL. And I personally think if you understand the rationale of IHL, you do not really have to go through all of the articles in the Geneva Conventions. By the way, there are around 600 articles in the 4 Geneva Conventions plus the additional protocols. And even if I'm not mistaken, not all of you are legal students or law students, but even as you don't have to understand the law. You don't have to really study the law to understand the rationale, the reason behind why this law is formed. So when you already understand the rationale, it is actually very reasonable, would I say, to understand why the rule is like this, why the rule is that, why we cannot starve the civilians, for example. It is very more reasonable, I would say, yeah, more reasonable to understand why, for example, in the situation of occupation, we would definitely want to preserve the lives and the sustainability of lives of the people in the occupied territories. But at the same time, we do have to adhere to certain occupying powers authority. So these are like the check and balances between all of the rules in IHL, in all of the rules of IHL. And we're talking about the third question in the second section. So we're talking about the where, who, and when IHL actually applies. So this is more on the technicality side of IHL. First thing first, to whom IHL applies, essentially to the parties to the conflict. So whoever are warring each other, parties to the conflict, be it states, be it non-state armed groups, and if there are times we might have to dissect this further because there are some standards of what considered armed groups under IHL, but essentially to make it easier to simplify it, IHL applies to the parties of the conflict. Whoever are warring, whoever are fighting each other, they must adhere or must observe IHL. And it does apply only when and where there is an armed conflict, when there is a war. It does not apply in other situations. And this is a very strict definition, a very strict line that must be understood. In a sense, easily, peacetime IHL would never apply, and it cannot apply. If IHL applies in peacetime, it would be in a way catastrophic, actually, because IHL does not work in the way that human rights law work, for example. In IHL, for example, you might find it necessary to kill the enemy combatants. These are the things that probably will trigger some discomfort under the human rights law, where rights to life must be preserved. But then we do have a situation of war, which is very extraordinary, very unideal, but some of these human rights law might need to be reassessed, not reassessed. I mean, human rights law, I would continue after this slide. Human rights law continue to apply in all circumstances, but there are some things, some rights under the human rights law that are simply not being able to be implemented in war times. Right to life is actually a non-derogable rights, meaning that it cannot be waived under any circumstances. However, what would be prohibited under this is a separate, this is more on the perspective of human rights law, but a right to life is a right that is non-derogable, that remains true and always true. But what is prohibited is actually the arbitrary taking of life. So when war occurs, when it is a situation that's so grave, there might be some taking of lives that are militarily necessary. IHL is more pragmatic in the sense that it might allow some of them in a way, and that's why probably I really like Francis' question earlier, casualties cannot be avoided at times in war. But still, even in those situations, there are limits, there are basic minimums under which the IHL governs its rights. I would continue to talk about this in the relations between human rights law and IHL. But essentially, what I would like you to understand here, it only applies in armed conflict and war. And if IHL, this role of IHL applies in peacetime, it would be difficult. It would be weird to have it say like right to a certain something cannot be upheld in peacetime. So IHL is really restrictive. And I think I saw a hand raised. Kian Jervin Tunggala. I think you raised hand, or was I?
Hello, ma'am. Good morning. Hello,
Morning.
morning. Okay, I have a question, ma'am.
Mhm.
Okay. So, do you think sanction to an invader country is enough to stop or demotivate them from invading? Does it unequal because civilians of that country suffer from the decision that was made by their leaders? For example, the sanction from the United States, Canada, and other countries to the Russia. That's
Okay, thank you. Do I spell your name right? Kian? Kian or?
yes, ma'am. It's pronounced as Kent.
Kent. Okay, Kent. Thank you, Kent. So yeah, a very interesting question, and it actually would relate to how we implement the law. The law already exists, but how do we actually implement it? And your question revolves more on the effectivity of a certain sanction, for example, and how effective it is actually to remedy war, to in a sense. This is where I would like to probably draw the limit, in a sense. What you were asking is more on the jus ad bellum. I can address that very briefly. Jus ad bellum, so the law on the use of force, or the law of the international relations in a more general sense. So, for example, sanction is whether it is effective to stop a country invading the other. I would say it depends, and this is more a question that cannot be purely answered through the law's perspective, legal perspective, because we do have to take into account the diplomatic law, the international relations law, public policy, and others. But essentially, yes, sanction is one of the mechanism probably under the jus ad bellum or the international law in general, not really focused on IHL, but under law in general, it is one of the sanction international measures provided. Whether it is effective or not, it depends. Sometimes yes, sometimes not. And there are other measures that can be forced to make some states obey a certain rules. Whether it is effective or not, it really is not something that I can answer. So apologies for that. It might sometimes be effective if, all things considered, some, depending on the situations, the power between the states. So there are other aspects that cannot really be answered by law. This is more on the international relations type of sphere, but yeah, it might be effective, it might not be. There might also be other measures other than sanctions that can be imposed, and whether all of those other sanctions effective or not, it can or cannot be. So basically the answer is it depends. Technically can't. So it might also not always be ideal. And I would admit that this is like one of the worst, or not worst, but the not repercussion, but like the drawback of international law, that sometimes it does have a more limited enforcement power than the others. I will probably come into that when we're talking about national implementation. Why is it important on my third slide? So I will keep your question a bit, but the short question, the short answer would be, it depends. So
thank you, ma'am.
Thank you, Kent. And I think I see another hand raised from Joanna.
Yes, ma'am. Am I audible, ma'am?
Yes, you are audible.
Thank you, ma'am. You have said earlier that IHL is more on limiting or preventing the casualties of war, ma'am, right? With this matter, ma'am, I would like to ask if there are certain events that the IHL can prevent war or can stop war, ma'am, and if they can, ma'am, what are the certain aspects to that, ma'am? I'm just a bit curious about it.
Okay, thank you, Joanna. And may I direct you, because I think your question is very important. It is very important to really hear the perception and definition of IHL. So whether IHL can stop war or not, it cannot, in a way that it is not built for that purpose, more in that sense. So when you want to say how to limit war in a sense of how to stop or prevent war itself from occurring, it is not what the IHL can do, but it might be something that other bodies of law, I will go back to the other slide, other bodies of law might want to govern. So this also relates to Ken's question earlier. You do have other public international law streams governing about this. So you can, whether a state is allowed to go to force, to go to war, and what are the sanctions and everything. You do have those in the UN Charter, in the law on the use of force, on the law of state responsibility. These are matters in which war is probably going to be limited or prevented in a way. So these are, and then there's also sanctions in terms of criminal prosecution, the aftermath of the war, how to prosecute the war criminals in the international criminal law, how to settle the dispute between two states in the dispute settlement law. So these are the laws that cover all of those stuff. IHL does not do that, not because it actually promotes war, not at all. It's not what, it just, IHL takes it on a very pragmatic sense, regardless of whatever political motivation, whatever the reason a war is waged, say that we close our eyes in the sense that if war happens and when war happens, in that war, there must still be limits. That's the limits that we are talking about when we're talking about IHL. So it really does not limit war from happening per se, not because IHL wants war to happen, not at all. That's not the way it is. It is just more that it is governed under another subject of law, another body or branches of law. What IHL does is when inevitably war occurs, what can we do in that situation? More like that. So I hope, yeah.
Very much, ma'am. I'm very enlightened by your answer. Thank you very much.
And thank you for asking, Jonah. I think this is a very important thing to clarify. Thank you for reminding me to clarify that. So yeah, basically that is IHL. And okay, before that, just very briefly, IHL, when I said it only applies to war or armed conflict, there is actually standards on what constitutes armed conflict under IHL. And there are technically only two types of armed conflict, the international one or IAC and non-international one or NIAC. And there are standards of what constitutes IAC and what constitutes NIAC. And it is very complex, to be honest, something that is probably also still questioned even until now. Not the standards are clear, but how do we interpret the standards? Those are what remain very difficult even for me. So we will not really touch base on that, although I can, if there is time, to elaborate more on the standards of each, but I just want to say that there are thresholds of what can be constitute armed conflict. It goes to say that, not just because for example, I'm holding a gun and then pointing it at my neighbor, for example, and that can be constituted because I am armed and because there is a conflict and that is an armed conflict. That is not the case. There's a certain standard where it really constitutes an armed conflict under IHL. Very briefly, like for international armed conflict, the standard would be when when a state uses their forces to another state. So it must be by a state. So in a very the capacity of a state to reach that. That's for armed conflict international. Non-international can only be reached by non-state armed groups to this, and so one party is a non-state armed groups and the other one is the state itself, or between non-state armed groups within a territory of a state. And there are standards how intense the armed conflict is and how organized the armed group is. So these are the standards. We will not really be dwelling too much on this. It will be very technical, but feel free if you want to have any question on this later on. This is just to say that there is a very strict standard on what constitutes armed conflict, because the consequence of applying IHL can be very severe. It is not a law that is meant to be applied on just any situation. It is meant to be exclusively applicable only in the situation of armed conflict that meets the standard under IHL. This is the applicability of the law. Just want to go to say that human rights law and domestic and national law, this is to say, like, for example, constitutional law, criminal law, national criminal law, and other laws that you might also have already or would learn in the future, these human rights law and domestic national law continue to apply in all situations, even in armed conflict. So human rights law and national law still apply even in non-international armed conflict or international armed conflict. IHL does not and would never and could not be applied in situation of peace or other situation of violence that do not meet the threshold or the standard of an armed conflict. IHL exclusively only apply for IAC and NIAC for armed conflict, whether it is international or non-international. So this is very important to understand. IHL cannot be applied in situation like for now, if we are at peace, we cannot apply IHL. IHL does not apply, simply not applicable. It is only applicable in the situation of armed conflict. And you might see, if for your task you want to discuss about the interplay of human rights law and IHL, that will probably get a bonus point for me because this is actually a very complex issue to understand. The interaction between the human rights law and IHL in the situation of armed conflict. So maybe you would find it weird when human rights law and IHL, I would say the relationship between these two bodies of law are complementary. They have rules, human rights law and IHL have rules that are compatible, that are similar, or I would say even same, do not torture someone. That is a rule that exists in both human rights law and IHL. But there are other rules that might seem contradictory. And when they are applied in armed conflict, it might make it a bit weird or difficult to apply it. And this is the interplay between these two bodies of law that are a subject of an extensive research, I would say. There are some school of thoughts on this. What I would probably want to focus on is very briefly on the interplay, and what I personally like to interpret it is more complementary, and these two bodies of law complements each other. And when there is inconsistency or there is what seems to be a contradiction, IHL generally applies when the situation is so very armed conflict-ish, but at its heart, at its core, there's what we call a maximalist approach. So it is aimed to see which one gives the best protection. That's where the interplay, that's just like one of school of thought. There are other school of thoughts actually, but just to give an overview that this issue is actually very complex when you're trying to say that in an armed conflict, what law actually applies. I would say that human rights law, domestic law, and IHL, all of them simultaneously apply, and they're actually complement each other, complete each other. When one is not governed by the IHL, it is governed by the human rights law. When it is not governed by the human rights law, it is governed by IHL. So those are more of like the relationship between these two bodies of law. And then the final question in the second part, how does IHL work, basically? So we have learned about IHL, where does it apply, when does it apply, in what situation it applies, but how does it actually work? And I mentioned this in the earlier stage. The two key words that you would have to remember to understand what IHL is protect and limit. And we also have another two types of parties, would I say. Those parties to the conflict or those participating in hostilities, military combatants, people who are actually fighting, taking direct part in hostilities. And there are those who do not or do no longer not participate in hostilities. So those people who are not or do not longer participate in hostilities, civilians, medical workers, people like that, they must be protected. That is the key essence of protection for those not participating in hostilities. On the other spectrum, for those participating in hostilities, and when they inevitably do their conducts of hostilities meaning like the hostile actions that they're taking, shooting someone, destroying a certain military target or things like that. Those are unfortunately allowed in IHL. The conducts of hostilities is part of IHL, but even those conducts must be limited. So from this, we do come back again to the whole scale of balancing between the humanitarian consideration and the military necessity in war, these two paradigms, these two perspectives. At IHL, I will actually, although this is a legal class, in a way, this is for legal, more built for legal audience. I would not really discuss about articles. I just want you to understand the principles behind IHL. So I will not really talk about articles or references, particular rules whatsoever. Just want you to understand the principles of how all of these are made. So protecting those not participating in hostilities, limiting those participating in hostilities, weighing and balancing between the humanitarian consideration and the military necessity. These are translated into, at minimum, 5 core principles. There are actually other principles, but I just want to focus on these 5 for now. Distinction, proportionality, precaution, limitation, and humanity. So essentially, distinction. First thing first, in war, when it is unavoidable, when you have to attack the enemy combatants, for example, that is allowed under IHL. But you must distinguish between those who can be attacked and those who cannot be attacked. So attacking military tanks of your enemy forces, those are permitted conducts of hostilities under IHL because they are military targets, but because they are participating in hostilities. But those who are not participating or no longer participating in hostilities, they can never be attacked. And this means civilians, this means hospital, this means school buildings, this means even wounded soldiers. Even when you have enemy soldiers or prisoners of war, they cannot be attacked because they no longer participate in hostilities. So even when they used to participate in hostilities, once they do not or do no longer take part in hostilities, their protection arises. They must never be attacked. That's the core principle, distinguish. So first thing first, distinguish which can be military targets and which are not military targets, essentially, to distinguish between these 2 types. And it applies to people and buildings and objects. And after that, I think this relates also to Francis' earlier question, proportionality. So true, in war, casualties occur, and sometimes we are, for example, I am an armed forces of a state, for example, and I must, by the necessity of war, attack the military target, for example, the military camp of my enemy. While that rule is allowed under IHL to attack the military target, it is allowed, but the effects, the causes, the consequences, or as Francis has correctly termed, the collateral damages, the incidental damages, can never be excessive to those who are not participating in hostilities, essentially. So when you're attacking, for example, a bridge, for example, because the bridge serves as a connecting point, it cuts, when you say, for example, in war, when you attack a bridge, because that bridge provides an essential logistic chain to the enemy's troops, and by a certain military objective standard, it meets a certain military objective standard, and you attack or you destroy that bridge, that is, when justified, it can be justified. But if it causes a severe, excessive, an overblown impact to those not participating in hostilities, to the civilians, to the well-being of the others that are not participating in the hostilities excessively, those are prohibited. When those collateral damages are not excessive, technically under the ICC or under the rules of more on the international criminal law, it is not per se criminalized, but when it is excessive, at least it is the one that is criminalized. Franz, I think you rose hand again.
Yes, ma'am. So when states preach about values such as protecting the sanctity of life, such as in the Philippines, where what do you call that? Death penalty is illegal, while at the same time they would wage war with other countries, causing or resulting in mass genocides and other atrocities. Doesn't that make them in some way hypocritical?
All right. First thing first, as the ICRC, because we are a neutral body, we cannot really comment on any action of the state in that way. But as a general rule, or just like in a very academic manner, I would just like respond first of all, death penalty is, of course, a very difficult issue to say under human rights law. Some think that it is a violation to human rights law. Some other think that it is justified because it is not arbitrary taking of life because there is a court judgment to that, and that is not arbitrary to some say. Some other countries really, what do you say, like reject the notion of death penalty. But anyway, yes, death penalty, and whether it is hypocrite, for example, to preserve life and then at the same time taking another life. Well, I would not say whether it is hypocritical or not, more because of we cannot really comment on any of those. But what I would say that, for example, situation of mass genocide, at least I would say, is a violation of a certain international law. There is, aside from IHL, which is governing mostly in armed conflict, you would also find, for example, in the ICC, it is an international criminal court, or under the more of a subject of international criminal law, it is criminalized for 4 types of actions: war crimes, genocide, crimes against humanity, and aggression, the act of aggression. These are the 4 types of crimes that are deemed so heinous, so damn heinous, I'm sorry for my language, so heinous that it constitutes an international criminal crime, basically. So while I would not address on the hypocrisy part, because yeah, I mean, some, well, worlds cannot be ideal, unfortunately, and I would not comment more than that, but just want to elaborate that yes, indeed, genocide is actually a violation of international law if one is committed. I just want to say that. Not necessarily, may or may not be under IHL, but at least under international criminal law, it is very, very severely sanctioned in a way.
Thank you, ma'am.
Yep. So, yep, the principles, these are 2 of the principles: distinction, proportionality. We do have the 3rd principle to further limit those effects of war, is to take precaution at all times. And this means that, oh, sorry, before that, I think Mel Rupert Balloon Honrado.
Good morning, ma'am.
Yeah.
I'm just wanted to ask, it is human rights law also applicable in armed conflict?
Okay, very interesting question. Let me go back to this slide. Yes, it does. Human rights law continue to apply in armed conflict, but the execution, or dare I say, I mean, how you implement those laws might not be always in a situation as easily implemented as it is in peacetime. Some rights inevitably, some human rights inevitably needs to be limited, not needs, but inevitably is limited in wartime. So it really depends on which rights are we talking about. There are some rights that are in any situations are non-derogable. They cannot be violated in any way, in any sense. Prohibition of torture, prohibition of cruel treatment, ill treatment, mutilation, all of these, even in war, you cannot do that. But there are some exceptions where certain human rights may not be easily as upheld in war, not because we do not want to, but because we cannot, simply we cannot. Like, for example, right to provide a cultural right, for example, a social right to education. Not that states do not want to give the rights to education in wartime, but sometimes these are rights that just cannot be upheld. School buildings are destroyed and everything. So, but whilst doing that, even in IHL, while the human rights law cannot be fully, quote unquote, fully implemented in wartime, IHL still does govern the very basic of those rights sometimes. So it really depends. When human rights law, depending on the types of rights, depending on the types of certain rights, because human rights are really divided into a lot of generations in the human rights law. There are some civil and political rights, social, cultural rights, the communal rights, and then the more digital rights, more in the 1st generation. But some of these rights can be upheld in war, some of those unfortunately cannot. And these are the interplay. Where it is not governed by the human rights law or where the human rights cannot be implemented, there is IHL to fill the gap. And vice versa. When, for example, IHL is silent on a certain something, you can always refer back to the human rights law. So these are more of the relations. Yeah, they continue to apply, but which one and to what extent a certain right can be applied in war, it actually really depends on the situation, basically.
Thank you, Mom. Thank you so much.
Yeah. Just to say, Rupert, Rupert or Mel, that is actually a very difficult question in the sense that human rights law and IHL's interaction, the interplay is very much debated, I would say, very, very much so debated. What I propose, not what I propose, but I mentioned about one of the school of thought, the maximalist approach, but it is actually very difficult to implement, to really know which one apply in which and whatsoever. There are some that are very straightforward. You can easily say, okay, this one does not apply, this one applies. But there are some areas which actually in an academic setting, it is very toughly discussed even until now, these interplays. But what I can say at this stage is that these laws, both of them continue to apply simultaneously and they complement each other. That is like the general norm. When one does not govern an issue, it is governed by the other. That is like the general simplistic way of saying it. But I just want to give you a heads up that on a more academic level, this complementary issue is actually very difficult to apply in real time. But yeah, it is for perhaps for another forum, but yeah, just wanted to give you an overview of that. Back again to precaution. So essentially this principle means that you have to limit and you have to prevent or precaution any conducts of hostilities, meaning that before you launch a bomb, before you do any hostile actions, think about the consequences, think about the limits and take as much care as possible. If it's possible to evacuate the civilians beforehand, do that. If it's possible to do warning, do that. If it's possible to stop the attack, do that. You know, so this is more of a principle that really, you know, any military action can only be done when it is really, really militarily necessary. When it can be avoided, avoid it. And there can also be two aspects of this: the active and the passive precaution. Active precaution is like like preventing yourself from launching a certain weapon that would cause excessive damages, for example. That is more of an active precaution. You also have the passive precaution, and where, for example, avoiding locating civilian populations near the military targets, avoiding building residential areas or apartments near a military barrack, for example. These are the passive precautions. So it works in two ambits. It tries to, at best, precaution the worst effects of war. There's also limitations. So even for enemies, even for combatants, military objects themselves, even when to some extent some attacks may be allowed under IHL, there are limits to those. You cannot inflict any unnecessary suffering or superfluous injury. You cannot really, you know, once you kill an enemy soldier, you do not have to really bombard him with more weapons, more bullets. You do not have to really burn him alive. You do not have to do all of the things that are not necessary to reach the military objective, in a sense. So there, even for soldiers, even for those participating in hostilities, there are limits that can be done to the enemies. Humanity is pretty much self-explanatory. You do have to apply humanity even in war, and the emphasis on the word minimum, because again, we do realize that in war, you cannot really, for example, say I become a prisoner of war and I'm detained in a prisoner of war camp. I definitely cannot ask for you know, access to internet, or I want to request this food whatsoever, you know. But even still, when we cannot really be fulfilled of the maximum treatment that we might usually get, at the very least, the minimum human treatment must always be upheld. This includes food, shelter, does not have to be luxurious, but the bare minimum must be provided. And to understand IHL and how IHL works to protect and limit this war, this needs to be read in conjunction. You cannot really interpret, oh, just say distinction, oh, just because I've done precaution, then it is okay to do whatever I need. That's not the way it works. These principles need to be read in all conclusivity, because at the end of the day, let me go back to the slide. This principle, all of those, and that they're using the balancing between the humanitarian consideration and the military necessity, it is to protect those who are not participating in hostilities and limit those participating in hostilities. And at the end of the day, it is just to prevent the worst effects of war. Basically, that's that. And that's how and why all of these principles need to be implemented in conjunction, in a sense. So don't say that just because I've already applied distinction, already distinguished between the military target and the non-military target, but that does not mean that you can really, without any remorse, just attack those enemy combatants without any limit. So understanding IHL must be complete, because this is the only way that we can reach that kind of balancing between the humanitarian consideration and the military necessity in IHL. I think this is, this is nearing the last part of the second section. Just want to give an overview of how IHL, what I provided was more on the principles, the gist of IHL, but this is just to show that there are actually other matters that are touched upon by IHL as well. We're talking about institution of occupation, for example. We're talking about when a state is sending peacekeeping forces to another state. We're talking about terrorism and counterterrorism. There are talks about weapons. There are rules about medical facility and how they must be protected. There are rules on how to preserve the sustainability of life and water, habitat, food. There are rules on how to treat those missing and even those who already die in war. There are a lot of rules. There are rules on emblems and signs, and why, for example, the ICRC has that sign and has that emblem, and who can wear it and what does it serve. There are rules on environment and how armed conflict might have effect, or the effect might be exacerbated by climate change. There are rules on technology, weapons that are unimaginable nature. So just to say that if you want to talk about IHL, probably this would relate on one of your other tasks. If you want to touch upon the issue of IHL, there are actually abundance of, and these are not only this, there are a lot of other aspects of IHL that can be related, even on journalists, on how war correspondents carry out their tasks in the war zone, for example. How do we talk to armed groups? How do we protect women and children? You know, a lot of other issues and thematics can be related to IHL, actually. So this is just probably to give you an overview of how this law, how IHL actually covers a lot of things as well. And probably also as a heads up, if you would just want to have a certain angle to your task, but essentially just to say how expansive this law, once you understand the principles, once those rationale of the laws can be understood, you can actually implement this on other as well. So basically that's that. I think this is the third part of the presentation. So once we already know what IHL is, I'm sorry, may I ask, Lealyn, do you want to ask a question or? Okay, sorry, thank you. And so, yeah, we already know what IHL is, when does it apply, how does it apply, why it is IHL, and why all of those senses. And we are talking about national implementation. And this probably relates more. I think you've already got like 3 lessons before this on internet. I'm not sure whether you have learned about the relations between international law and national laws, but we're talking about that generally, how IHL is not implemented in a sense. And we have to understand the concept as one of the branches of the international law, public international law. There are difficulties. There are challenges on how international law can apply. Depending on the states, international law, public international law, including IHL, may or may not be directly implemented. And this, we're talking more about theories in this section. So in terms of the relationship between international law and national law, there are two main school of thoughts, monism and dualism. Essentially, this is the school of thoughts governing which prevails in essence between international law and national law. So in a monism theory, and it depends, some states might implement the monism, some states might apply the dualism, some might incorporate them. And even if you ask for Indonesia's case, whether it is actually monism and dualism, there are still debates on that, although there are tendencies to lean to one than the other, but it is very difficult to sometimes determine whether a state follows which category. But essentially, just to give you an overview, that monism essentially means that international and national law is part of one unity. One is sourced upon the other. And there is a monism which is more, saying national law primate, meaning that this school of thought, monism, national law primacy, concludes that international law derives from national law. It is because states make contracts or make agreements with each other that international law come to be, because it is sourced upon national law, and that's how international law becomes. So, but they are one, but just that one is originating from the other. And then there's another primate, the international law one. This is meaning that national law must be sourced upon international law, meaning that, when you're enacting national law, you cannot really go beyond the limits of what international law already governs. That is essentially the explanation between the monism. So international law and national law is considered one, just that one is sourced upon which there are differences. Then there's the dualism, as the name suggests. International law and national law are treated as two things. They're distinct, and international law cannot apply directly, and they have to be translated into domestic or national law. Now, on these theories, there are no rights or wrong. It is not to say that monism is better than dualism or whatsoever. No, it is not the case. And this is why, because states have sovereignty, one of the most basic principle in international law, because international law is the law that governs the situations and the relations between states, and all states are sovereigns. All states have their own sovereignty. One, legally speaking, is not above the other. Legally speaking, when we're talking about political matter, that is a separate case that I'm not going to discuss here. But legally speaking, it is the very core principle of international law that all states are equal and they are sovereign equals, meaning that international law does have, and at the end of the day, really need to be related to national law. And sometimes that is only how the law can be implemented. So this is to understand the relation in the first place. Why? Not only IHL, actually, all international laws. This applies to all international laws. How the relations between these two. So on IHL specifically, we do remember that there are these treaties, the Geneva Conventions, which, by the way, is actually universally ratified. This is actually quite a feat, even in international law, to have virtually almost all states ratified the treaty. For references, there are 196 states that ratified the Geneva Conventions. It is on the fifth or sixth, I forgot, most ratified conventions in the world. The other 4 or 5 conventions that are more ratified than Geneva Convention talk more about ozones, if I'm not mistaken, and more environment-based. But on the humanitarian aspects, this is like the most universally ratified treaties. Then we also cannot forget about the customary international law, which continues to bind even when a state does not ratify a treaty, basically. Although there are issues on customary international law, because the difficulty of customary international law is that exactly because it is not written, sometimes it is hard to tell which one is actually customary international law, but that's a separate discussion. Just want to say that even when there is an international law, and actually all of the states, at least the ones that are present in this forum at the moment, they are or have ratified the Geneva Conventions. And that means they want to be bound by the Geneva Conventions, and there is an international law binding them. But even when there is a binding force from the international sphere, the national implementation remains very important. Because before, even when there is an international law in the previous slide, even when there is an international law, sometimes in reality, this law cannot really be implemented directly. And that's why national implementation remains very important, especially when it governs the situation of war, where, as you can imagine, when war occurs, there's no other time to do anything else, basically. You do not have time to really build a law. You do not really have time to train people to understand law. You do not really have time. Basically, you do not really have the resources to really implement it unless you prevent them, unless you build this kind of awareness, unless you really prepare everything, prepare the system early on. And that's why even when there is no armed conflict taking place, from the prevention perspective, IHL remains important to ensure respect, to ensure adherence, national implementation, so that IHL can be applied when worse come to worse, war occurs and a breach occurs, the system is working. So that's really the reason why national implementation is very important. And I think this is the only reference to article I would have in the slide, if I'm not mistaken. So there is a duty for all state parties to the Geneva Conventions to respect and ensure respect for the convention or the protocol of the international humanitarian law. This means basically they agree to uphold the IHL. That is already a commitment built under the very first article of the Geneva Convention. This commitment to respect IHL. But sometimes, again, when it comes to states, when it comes to national implementation, it is not as easy as it is. International law has weak enforcing mechanism, and that's why probably, I forgot, was it Kent's question the other day when we were asked whether sanction is effective or not, whether a certain measure, a certain enforcement under the international law bodies, for example, are they sufficient? Are they effective or not? And sometimes, unfortunately, the answer is maybe yes, maybe not, and sometimes they're not effective sometimes. And how to make it stronger? It is not to say that international law is very weak. It is not that case. International law is strong. It's just that there are some drawbacks that might only be implemented when there is a strong mechanism to implement them at the domestic or the national level. And this is why national implementation is very important for international law. And how to implement IHL, there are lots of ways. We can begin as simple as for the instruments, adopt it to the national law, adjust the national law that are already there. Make sure that if there is a breach, for example, a war crime, or if there is say, for example, genocide, even though it is already penalized, criminalized internationally, make sure to make it stronger, criminalize it under the national laws, establish the implementing regulations, translate all of the instruments, include in the training of the military, include them in the dissemination of the policymakers, identify and mark the objects that are not meant to be attacked, cultural property, nuclear facilities that can never be attacked, passive precaution when you're building something, do take notice on this, do not build something, planology, do not build, military barracks near civilian population as far as possible, facilitate the special zones and their safety zones, provide safety, neutral and hospital zones when possible, prevent the abuses of emblems, do not make sure that there are no disrespect to the emblems. Just a brief overview, emblems is very important under IHL as well, because you might also notice that, some medical workers, they have to go to the front lines, they have to go to the battles, but they cannot be armed. They cannot carry weapons essentially. But how are they going to go with their humanitarian mission if not protected? And the emblems actually serve as a sign, as an identification of these are the peoples that cannot be attacked. So you might also find it in a lot of war movies, for example. There are some military combatants that are wearing a Red Cross emblem on their left-hand side, left arm band. That is to indicate that they are those who are protected under IHL, and they cannot be abused. The youth cannot be abused, so that in wartime they can be protected. That is essentially a very brief overview of how emblems are very important to protect those who are meant to carry out their humanitarian missions. Essentially, but this is just to give an overview of how important national implementation is and what can be done about that. These are examples in Indonesia. Legal-wise, there are some laws that are already enacted for this purpose. I'm not really going to really dwell on this. Just want to focus more on the other non-legal instruments. There are national committees, and I will address more about this later. Translation and dissemination, trading, etc. This is what have been done in Indonesia's context. And actually, the importance of the National Committee of IHL. So essentially, first thing first, there are actually national committees in Malaysia and in the Philippines as well. And this is actually a very effective tool for implementing IHL. So the benefit, this is more a government-based initiative where a specific committee is quote unquote mandated to promote and implement IHL in each state. And oftentimes these are cross-ministerial. So for example, you have the elements from the Ministry of Foreign Affairs and the Ministry of Defense and then the Ministry of Domestic Affairs, for example, the Ministry of Law, and all of those institutions that are relevant, they facilitate the coordination. So this committee, they facilitate the inter-coordination between all of these different institutions. And it gives a comprehensive perspective of how a state can promote and interpret their IHL policy, this national committee. It is also something that is agreed by the states. So there is a Red Cross and Red Crescent international conferences where the state parties to the Geneva Conventions, which is virtually almost 196 states, meet in a conference and resolute to bring IHL home, meaning that how to implement this IHL, this international law better at the national level, national implementation. And examples of NCIHL or National Committee of IHL in Asian countries, ASEAN countries, there are some that are ad hoc and some are permanent. Not to say one is better than the other, because there are the pros and cons of all. And really, I honestly don't consider it like it is always better to have it permanent or whatsoever. But yes, there are some in all of these countries also, they also have their own forms of national committees in their domestic legislation. I might not be as well versed as well what exactly they look like in Malaysia and the Philippines. But yes, we can confirm from the ICRC side that there are national committees in both of these countries as well. And in other states as well, more than 117 states have national committees of IHL. And sometimes these national committees work with each other. For example, in the Middle East, there are lots of cooperation between all of these national committees of IHL. Essentially, that is that. This is the last part, last slide. Yes, this is the last slide. So we already understand about IHL, and really at the outset, I did give that chart where why do we learn about IHL? Why is it important? Essentially, it is to prevent the worst effects of war. And how to do that is to ensure that IHL is respected. And this is really a very continuous effort to implement IHL. And in implementing IHL, ensuring respect to IHL and respecting IHL must be first understood. IHL must be understood and IHL must be known. So this is a continuous flow of process. Involves a lot of parties, and the approach might need to be tailored accordingly through each state, each context. But essentially, as long as the core essence of IHL is understood, as long as we understand what this law is about in the first place, then yes, hopefully, this IHL can be respected more in the future. So I think that's it. That's the end of my presentation, I suppose. Thank you for your time. Any questions? And or discussion. I don't really require you to ask questions, or if you want to ask about the task or anything, just feel free to shoot it out. So I probably am returning to Bu Ridayana again if there are any questions, but if not, it's fine. If you want to know more about IHL, I would be glad to, provide you with more materials if needed. You can start from the ICRC side, and yeah, basically. I think there's a hand raised from France.
Yes, ma'am. I would just like to ask if it does war have a direct impact on the economy?
Definitely, yes. The answer would be definitely. Although this is not exactly covered by IHL per se, but yes, well, some aspects of it are covered by IHL, but definitely impacts the economic. And sometimes the other way around. Sometimes it is the economy that causes war, economic motivation and whatsoever. And these are really complicated matters. But yeah, of course, I mean, like war, as easy as you're destroying a building. And then there is what in IHL we call the reverberating effect. And especially when war is conducted in urban or popularized area, heavily densely populated areas, attacking one can really resort to a lot. For example, you're attacking just one electricity generator, it can definitely affect the hospital. It can definitely affect the public utility system, the drainage, the water, the people, definitely it has economic effects, and widely so. So yeah, war is unfortunate, definitely from all aspects. But just to say that if again, IHL, while it does not really govern, but the justification whether a war is right or not that it is not available. I mean, the rules are available, just not under IHL, but IHL's focus is more on when war already occurs, what needs to be done. Basically just that. Want to keep on repeating that message, but anyway, thank you. Mercedes and Ivy. Mercedes first, I think.
Yes, ma'am. I just want to ask, ma'am, what happened or what will happen, or is there like a procedural detention if someone gravely violated the law or the international humanitarian law?
All right. So this is more on what the implementation, enforcement of the IHL and international law in general. So I would just like, yes, there are ways to detain. First thing first, on implementation, it actually begins with states. So when there is a violation of IHL, the one party that is first be held, quote unquote, responsible to enforce the law would be the state itself. So they may prosecute them on the domestic level at the national courts, those kind of violations. But when a state is unable or unwilling to prosecute such crime, for example, then they might really, there are other avenues that are provided under international law. It does not necessarily need to be settled legally. In a sense, it does not always need to be through courts. Sometimes it can be through sanctions. Sometimes it can be through the cutting of the diplomatic ties. There are other avenues on how to enforce these laws. The international criminal law does provide some of these sanctions in the terms of the word is not exactly detention, more like imprisonment for the war criminals. In other cases, there might be death penalty, but in ICC at least, or the International Criminal Court, that no longer is upheld. There is no longer death penalty in under ICC. But as you can see, for example, in the World War II, there is the Nuremberg War Tribunal, and they do inflict the death penalty back then. There are other sanctions as well. So it's not only detention. For example, if it's like between states, there might be requests for compensation, reparation, and also the request for an apology kind of. So there are many avenues, and yes, detention or imprisonment is one of them. But yeah, not the only one, but yes, definitely one of them.
Thank you, ma'am.
Yep. I think I forgot which one. I think Ivy was next. Ivy.
Hi, ma'am. Good morning.
Morning.
Thank you for the acknowledge. Ma'am, I have a question about the refugee. Is the IHL have the direct power or impact in the refugees seeking refuge to those countries, to the countries that they are going or they are seeking refuge, ma'am? Is the ISL have that kind of power to help those one?
I'm assuming you're asking IHL, not the ICRC, right?
Yeah, the
IHL.
IHL, ma'am. Yes, ma'am.
Yeah, okay. IHL does cover a plenty of rules on refugees. It does provide some sort of protection to those refugees, particularly those fleeing from conflict areas. But this body of law is more vastly governed by the refugee law. So when we're talking about IHL, we're talking about Geneva Conventions. There is actually a separate refugee convention, 1951, that really is very expensive on governing how a refugee must be handled. Just for references, the body that is more governing this is the UNCHR, the UN Committee on the Refugee. And I think what I want to stress on the refugee law and how does it actually protect, one of the most important principles, the non-refoulement. So that means that as a refugee, you really cannot be transferred back to the state where you are feeling threatened or something. There are a lot of standards as well. I must admit that I'm not really an expert on the refugee law, but there are some rules of refugee under IHL. It's just that it is quite minuscule in comparison to the actual refugee law. But there are some rules on IHL, refugees on IHL.
Thank you, ma'am, for the clarification.
Thank you, Ivy. And then I think lastly we have Aaron.
So good morning, ma'am. I would like to ask question is, what is covered by humanitarian law in terms of providing material assistance for those armed conflicts victims?
Okay, so what is covered by the IHL in terms of giving, the term coined under IHL is humanitarian assistance, and it does give all right, so let me explain it this way. So first and foremost, IHL covers that civilian populations must not be denied of their rights to sustain their lives, meaning that they have to get food, they have to be water, all of those things that are needed to preserve their lives. And in situation, for example, in the occupation territories, in the occupied territories or in armed conflict, the power, the authorities, the government must actually ensure that these populations are provided with those. In the event, so there is an obligation for states to provide for this. But in the event the states are unable to, they must allow for a neutral and impartial humanitarian bodies to actually facilitate that humanitarian assistance. And this is also an interesting point of where humanitarian consideration and military necessity becomes important, the balancing and the push and pull, because while on the one hand, we do have these rules of the requirement, the obligation under IHL to allow humanitarian access, humanitarian assistance, but states still actually have the authority to limit to an extent those humanitarian activities for a myriad of reasons, security, because unfortunately, there are some bodies, some probably, I'm not referring to any, but the smuggling of weapons through the humanitarian assistance, etc. So it might actually cast doubt on this humanitarian assistance. That is why actually IHL protects those who are impartial and neutral in carrying out their humanitarian assistance. They must be provided for that leeway, for that passage. The government can limit them in a way of checking, just like, checking, okay, whether among these foods there are weapons smuggled or something like that. But essentially, they cannot be prevented per se. They can be checked, but not really refused in a way, ideally. And IHL provides that. But there are limits. I mean, ICRC was one of the body that was, not to promote the ICRC, but yeah, in the end, yes, it is also one of the body that is specifically mentioned under the Geneva Convention to be neutral and impartial, but that does not only limit it to ICRC. There are other international organizations, as long as they fulfill the standard of being impartial and neutral. And when they're caring for the humanitarian assistance, then states must allow for these passages of material goods to be delivered. And when we're talking about this, I mean, like the forms, it actually varies a lot. It can be food, it can be shelter, it can be pipes, how to build the water system, and a lot of stuff. If you're interested, there are actually a lot of what we do at the ICRC in facilitating all of these material needs of the population in terms of armed conflict. So that's that. I'm sorry if I get it wrong and not really addressing your question, but basically, yes, there is an IHL rule on humanitarian assistance and allowing access to that humanitarian assistance in the event the state cannot provide or sustain the sustainability of the people, basically. All right. If there is no other question, I'm returning it to Bu Ridayana.
Okay. Is there another question? I think that's all.
And thank you for the interest on IHL. I'm really pleased, if more people are getting to be more interested in this body of law, because as I said, it might sound weird and controversial at times, but really at the heart of it, it is something, in my opinion, a very reasonable and a very logical law. So yeah, but you do need to understand the push and pull between all of these to understand IHL. But thank you so much for the interest and time for listening to IHL Pep Talk. I'm returning it to you, Biridayana.
Okay, thank you. Okay, this will be a closing for today. Thank you very much for Mrs. Adining Tias S. Jatmiko from ICRC. And then thank you for your attention and see you in the next class. Good afternoon. Wassalamualaikum warahmatullahi wabarakatuh.
Afternoon. Wassalamualaikum. Bye-bye. Good luck for
Thank you,
the remaining of your class.
Bye, ma'am.
Thank you, ma'am.
Thank you, ma'am.
Thank you,
Ma'am. Bye, ma'am. Thank you, ma'am.
Thank you, ma'am.
Thank you, ma'am. Thank you.
Thank you.
Yan, ketemu.
Thank you, ma'am.